I'm glad that you did. Mr. Westmont wants you to come in.
I didn't respond.
No, don't respond. Don't
There's
engage.
over, I was just,
Yeah, no,
answered his 3 questions.
you
saying it's
you
good.
did just right, but don't engage.
No, I'm done.
Yeah,
I just put it in a folder, I'm done.
yeah.
Put my DSAT folder, I'm done. Reading that this morning, it's like, oh,
No.
thanks for your background, I'm not jumping on board.
Absolutely. That's what we want you to do.
Good morning, everyone. I have 8:30, so we're going to go ahead and get started. Just on time, Jim. Good. I thought we were going to need you for a quorum, but we have a quorum. At this time, I'd like to call to order the Escambia County Planning Board rezoning hearing for July 6, 2021. We do have 5 members, resulting in a quorum. At this time, I'll ask everyone to please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, and good morning, everyone. Please turn your phones to silent so we don't interrupt the meeting. And staff members, do we have proof of publication of the hearing?
Yes, sir.
Okay. And does that publication meet all of the legal requirements?
Yes, sir.
Okay. Chair will entertain a motion to waive reading of the legal. Motion and second. All those in favor say aye. Aye. Opposed? Motion carries. I'm sorry. Are you okay? The rezoning meeting minutes from the previous meeting have been provided to the board members. Are there any additions, deletions, or corrections? Hearing none, Chair will entertain a motion to accept as is. Motion?
Second.
Second. All those in favor say aye. Aye. Opposed? Motion carries. The rezoning hearing package for July 6 with the findings of facts has been previously provided to all board members. The Chair will now entertain a motion to accept that rezoning hearing package with the findings of fact and the legal advertisements into evidence. Do we have a motion? Motion?
Second.
Second. All those in favor say aye.
Aye.
Opposed? Motion carries. The rezoning hearing package and the findings of facts, as well as the legal advertisement, will be marked and included the record for all of today's cases. At this time, we'll ask our court reporter, Dave, to please swear in the members of the staff that will be testifying in today's hearings.
Everyone raise your right hands, please. Do you solemnly swear or affirm the testimony about to give in this case, these cases will be the truth, all the truth, and nothing but the truth, and so you do affirm?
I do affirm.
Board members, you've previously qualified these individuals to offer expert testimony in the area of land use and planning. Do any of you have any questions regarding their qualifications or their ability to offer this expert testimony? Hearing none, let the record reflect that these individuals for the staff will be offered as experts in the area of land use and planning. At this hearing, the Planning Board is acting under its authority to hear and make recommendations to the Board of County Commissioners on rezoning applications. The hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings, however, they are less formal. All testimony will be given under oath, and anyone testifying before the Planning Board may be subject to cross-examination. All documents and exhibits that the Planning Board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the Planning Board will consider the relevant testimony, the exhibits entered into evidence, and the applicable laws. Each individual who wishes to address the Planning Board must complete a speaker request form. They're located at the back of our chambers. You will not be allowed to speak unless we have received a completed form. Please also note that only those individuals who are present here at the hearing and give testimony on the record will be allowed to speak at the subsequent hearing before the Board of County Commissioners, the BCC. No new evidence can be presented to the BCC, therefore all testimony and evidence must be entered today. The Planning Board will provide a recommendation for each rezoning request to the Board of County Commissioners. They will then review the testimony, documents, exhibits, consider the closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of that decision must do so in a court of competent jurisdiction within 30 days of the date that the BCC either approves or rejects the recommended order of the Planning Board. All written or oral communication outside of this hearing with members of the Planning Board today is considered ex parte communication. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution 96-13. As each case is heard, the chair will ask any board member that has been involved in any ex parte communication, please identify themselves and describe that communication. The board considers these criteria, the rezoning criteria, as required by Section 2-7.2 of the Escambia County Land Development Code. The Planning Board's recommendation to the BCC shall include consideration of the following 5 approval conditions. The applicant has the burden of presenting competent substantial evidence to the reviewing board, establishing that the requested zoning district would contribute to or result in logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area as required for the mailed notifications. A logical and orderly pattern shall require demonstration of each of the following conditions. Consistent with the comprehensive plan, the proposed rezoning is consistent with the future land use category as prescribed in LDC Chapter 3 and with all other applicable goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU amendment, it must be transmitted to the state for agency review. The proposed rezoning is consistent with the proposed FLU and conditional to its adoption. The next one is consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning established provisions prescribed in the in the district for the chapter. Compatibility with surroundings. All of the permitted uses of the proposed rezoning, not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with the surrounding uses. The uses of any surrounding undeveloped land will be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing the compatibility of a residential use, there is no additional burden to demonstrate compatibility of specific residents or activities that are also protected under fair housing laws. Appropriate if spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6, the isolated district would nevertheless be transitional in character between the adjoining districts, or the differences with those districts would be minor or sufficiently limited. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balance of interest between the isolated district and the adjoining lands. Appropriate with changed or changing conditions. If the land uses or development conditions with the area surrounding the property of rezoning have changed, the changes are to such a degree and character that is in the public's best interest to allow new uses, densities, or intensities in the area through rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to contribute to or create sprawl. At the beginning of each case, as long as there are no objections from the applicant, We will allow the staff to briefly present the location and zoning maps as well as photography of the property. Then we'll hear from the applicant and any witnesses that they may wish to call. Next, we'll hear from any staff witnesses, and then we'll hear from members of members of the public who have filed a speaker request form. It looks like we have 2 public hearings today, and with that, we will go ahead and get started right away. The first case is rezoning case Z 2021-05. The applicant is Escambia County. The address is 5701 Highway 99. The property size is 28.71 acres, and it will be asked to be removed from RMU, which is Rural Mixed Use District, 2 dwelling units an acre, to Ag Agricultural, 1 dwelling unit per 20 acres. Okay, who's going to be presenting on behalf of the county?
Oh, yeah, I need to be sworn in, sorry.
Okay,
Do you solemnly swear testimony about to give in this case with the truth, the whole truth, nothing but the truth, so help you God?
I do. Andrew Homer, Escambia County Development Services.
all right, thank you, Andrew. Before we get started, members of the board, has there been any ex parte communication between you, the applicant, agents, attorneys, witnesses, fellow planning board members, or anyone from the general public prior to this hearing? Also ask if you have visited the subject property. Also disclose if you're a relative or business associate of any of the parties. Morning, Tim.
Morning, no to all.
All right, Chairman, no to all. I am familiar with where the site is located, but I didn't visit specifically for this case.
No to all.
No to all.
No to all.
All right, thank you. Staff, was a notice sent to all interested parties?
Yes, sir.
Okay, thank you. Was it also properly posted on the subject property?
Yes, sir.
Okay. And I'm assuming that the staff doesn't have an objection to the staff presenting the pictures, so we'll go forward with that, please.
All right, as said, this is Z 2021-05. This is the location map. This is the 500-foot radius showing the zoning. The current zoning on site is rural mixed use. Is there existing land uses in the site, around the site? The future land use is rural community. And this is an aerial map of the site. Public hearing sign posted. This is looking south along Highway 99, looking north along Highway 99, and looking west onto the subject property. And this is looking east across Highway 99 from the subject property.
Okay.
It's my understanding we don't have any speakers.
Yes, members of the public, in cases when the applicant meets all of the criteria and we don't have anyone from the public signed up to speak, we do an expedited forum because it does meet all of the criteria. Is there anyone who wishes to speak on this case present? Okay, hearing none, we'll close public comment. I think it would be ideal just to go ahead and give a little background on it so the board knows. I know they've read their packages, but just a little background. We don't have to go through every criteria because we know it meets all of the criteria, but just a little background. Thank you, Drew.
Yes, sir. So this parcel is owned by the county. It's used by the 4-H club. There's an adjacent parcel to it that is zoned ag. And what 4-H would like to do, and they've asked the county, is if they could just kind of clean it up and have the same zoning across both properties. While it's not cumulative zoning as it used to be, there are some uses in ag that they would like to be able to have if need be, that wouldn't go through with the rural mixed use, so they just want to clean it all up and make it one zoning for all their properties.
Okay. And that was always the intended use of this property, was for what's being proposed, is that correct?
That is correct, yes, sir.
Okay. Board members, any questions? All right. Hearing none, Chair will entertain a motion on public hearing 6A.
Based on findings, I make a motion we approve 2021-05.
Okay.
Second.
Motion, second, Tim, okay. All right, all those in favor, say aye.
Aye.
Opposed? Motion carries. All right. Our next case is a public hearing concerning the review of a revision to the Antietam subdivision, which is a PUD, a planned unit development, that the board will review the revised development plan for Antietam residential subdivision, a planned unit development PUD, and confirm consistency of the plan with the Land Development Code requirements prior to submittal of a recommendation to the Board of County Commissioners. They will then consider the plan for final decision. All right, who's going to be presenting on behalf of the county?
John Fisher.
Okay. John, if you go ahead and give us the background. We do have some folks here to speak on the matter today.
Okay, very good. John Fisher, senior planner. We can kind of go through the maps first to give an idea where this was, then I'll go into a little more of the details. All right, so this currently is a approved master plan. You can see what's been platted. Actually, Phase 3 has been platted too. It's just not, we don't have the updated lots there that you see are highlighted there. So this was a regular 200-plus lot subdivision, and there's one area that they want to basically carve out another lot. There's some history behind this, and we can get a little more detail as we go through the findings. There's the mixed-use suburban future land use. This is the flood zone map. This is showing the aerial map. This is the public hearing sign. This is Antietam. You can see it's already mostly built out except for Phase 3. They're just starting to build houses in Phase 3 now. If we can go to the master plan map. Okay. So this is the new master plan map that they are going through DRC right now. In order for them to move forward, they must have approval through the Board of County Commissioners. They had I'm going to take this cursor here and we switch hands, excuse me. So we have a park right here, and I'm not going to go into the full detail unless it really needs to be brought up. They basically, in the overall, from the original master plan, they had a number of lots that was proposed for 198 lots. They want to increase the overall master plan to 199 lots. So in order to do that, they had to come back to the planning board and BCC because that was not the original number. Anytime we increase the number of, density or change lot configurations, we need to come back to the board to just basically get that solidified. So all it's really doing, the simplest way to say right now is they're taking an existing park that straddles Phase 1 and Phase 3, and they're going to have to replat Phase 1 in order to make this work. And we've gone through this in very detail in-house, so this gets kind of a little more complicated on the platting process end, but that's through DRC for this. But the whole goal in mind is for them to add one additional lot to the overall master plan. So they've revised their master plan. It's gone through DRC. They're using the same setbacks that were approved in the original master plan, so there's no changes to the reduced setbacks and lot widths that they had approved back in 2016. Some of you may remember this coming through as a nice PUD. Currently, they have 197 lots. The other reason for this shift, the plat did not come out as correctly designed when it was first done. The master plan is not platted at the time it's approved. It's just a conceptual design. Down here we have an ECOA easement. This was not here in the original master plan, at least not this width. ECOA asked for, basically like a 15-foot easement, which made all these lots shift down to the east. Okay, so when they did that, they ended up losing a lot overall. And they were just trying to get that lot back as well as gain another lot through, which is a little entrance to a trail park area, which there's a bike trail that's still, not a bike trail, but a multi-use path that goes around the whole subdivision. It's not impeding that park at all. Staff has no rejections to this process. It's just part of, the process that they need to go through in order to get that additional lot that they have.
Okay. I need to do a housekeeping item here. I failed to ask the members on the board if there was any ex parte communication with you, the applicants, agents, attorneys, witnesses, fellow planning board members, or anyone from the general public. Also ask if you have visited the subject property and disclose if you're a relative or business associate at any of the parties. Tim, on this case?
Nope, I know where it is, but no to all.
Okay. Chairman, no to all?
No to all?
No to all.
And at all.
Okay. Just want to make sure we got that on the record, that there was no ex parte. Okay. Board members, any questions? Mr. Fisher?
Yes, I've got one question. So in your estimation, when a developer comes before with a planned PUD, they usually give up things or offer things. So is it your opinion that by granting this extra lot, there's nothing being taken away from that said concession and or from the community as a whole?
No, they still have a park that exists there. They're just shrinking that park down a little bit. The trail from the road still is there for them to use. It's just part of the process. They're still having, all the sidewalks have been put in, all the street lighting, the landscaping as you know was added to this, the pool amenity, the trail was part of the amenity that was part of the PUD in order for them to have the reduced setback. So they're still meeting all the requirements. They just, with the lot line shift that they had to replat it anyway, and they figured they could probably squeeze one more lot in there, so they're just wanting to go through that process.
So to clarify, Mr. Fisher, you threw out three numbers, 197, 198, 199. They have 198. They probably lost a dwelling unit possibility with the ECU easement, is that right?
Correct.
Okay, so to get them back to net, they need to add a lot to achieve their dwelling units.
Correct. This is where it starts getting complicated.
Yeah.
Okay, so in actually phase 2, up here, they actually add an additional lot. So this is where the math gets kind of confusing too. They add an additional lot in phase 2 here on the end, which was not part of the original master plan. When they came through phase 3, they platted everything as you see here and there on the new master plan. If we would compare to the old master plan, you wouldn't see this easement here, and you just see one lot down here.
Right.
But they could not plat it due to it falls in phase 1 as well. So they have to replat phase 1 in order to get the lots that they need. The phase line goes right through phase 3 and phase 1. So it's a very tricky situation what they have. So that's why they have at the very top here, it says replat tract A phase 1 and parcel G phase 2 to equal 2 proposed lots. So they have in the overall, each development order totals up to, so there's 3 development orders, phase 1, phase 2, phase 3, right now equals 197 lots, okay? They were approved for 198 in the overall master plan from back in 2016 from this board. They're looking to gain that lot back that they lost and add an additional lot for 199.
Okay. Any other questions? All right, Ms. Crawford, did you wish to speak on this one? Oh, I'm sorry, you signed up for regular planning board meeting, I'm sorry. Okay, I'm sorry, we do have someone, Melissa Curry. Good morning.
Good morning, everybody. I'm Melissa Curry with Dewberry Engineers, and I'm here on behalf of our client,
We'll
that
have
is the
you
developer.
sworn in, please.
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Thank y'all so
Thank
much.
you. Go ahead.
So it is a little complicated, a little convoluted, but what really happened was there was some sort of miscounting that happened during the construction phases. So as was pointed out, there were 3 different construction phases, and with each phase, a development order was pulled, and we have had a total of 199 lots that were part of the development order. Then that was shifted and changed, and because of the way that the lots fall within the different phases, we ended up losing a lot. So what they're trying to do is have the lots that get platted equal the number of lots that were part of the development orders. And the reason why that's important is because with the development orders as they were obtained, the lots were built on the ground. So the infrastructure was put in, the water and sewer utilities were all put in for these lots. So everything is already in place and existing for these lots. The slight modification that was made to the park area is just taking 52 feet out of that area to allow for this additional lot in order to match the development orders that were issued over time and the number of lots. There's a discrepancy between that number and what has been platted, so we're trying to get those numbers to match. So it doesn't match the exact number that was on the original master plan of the 198, but with every development order that was submitted, there was an updated master plan submitted along with that development order, and on that master plan, it each time showed 199 total lots. So in somewhere along the way, there was a lot that got dropped out, but from a construction perspective, there was the development orders that were in place, and as was pointed out, the utilities and all were put in for these lots. The other thing that I just want to point out is this does not increase the density. By one lot over 80 acres doesn't really affect the density. When the PUD was originally approved, the zoning allowed for up to 4 units per acre, and we're still below 2.5 units per acre, so well below even the original zoning density allowed. So we really feel like this is a very minor thing, but the reason that it's important to the developer is because of contracts and things that they had written based on 199 lots. And so we're just trying to get those numbers to jive with each other.
One thing just for the board. When she mentioned the master plan was put in, the 199 lots was going through, it was, for some reason, it was snuck in with the construction plans, stuck in there, but it was never reapproved. We were still going off the original master plan of 198 lots. They had revised their master plan as construction plans, as part of the construction plans being one sheet in there, which should have never been really part of the approval. So one additional lot was put in phase 2, which threw a number up in phase 2, and we were basically subtracting that lot out of phase 3 because they were only approved for 198. So I'm saying this gets very complicated. We've had like meetings after meetings after meetings trying to figure out how to do this together. And since they want to increase the number of the overall master plan that was approved by the BCC of 198 lots, they have to come back here and go back to the boards to have that one increase. The development order does not increase the number of lots that was submitted with the construction plan. That has its own separate development order. Every master plan has its own separate development order. So there's actually 4 development orders: a master plan, phase 1, phase 2, phase 3.
Okay.
I would just like to say I don't think that the lots were snuck in. It was, there's been some sort of error, and we're just trying to correct that.
Yes, we've all been working with this.
Yes.
Long time. It's very convoluted, so it's, it's very convoluted, it's very confusing, but I think we're here at this point. It's up to the board. If the board wanted to make this over a couple of lots, two lots, so it's very convoluted, and they have been gracious to try to meet with us so they can try to get to the point where we want to go for the developer.
Okay. So noted. Mr. Fisher's comment was not snuck in, stuck in. So, but I understand why you'd want that on the record, so.
Yes, sir, thank you.
Okay. Board members, any additional questions? We have anyone else from the general public that wishes to speak on this matter? All right, sir, I don't have a speaker request form, but we'll allow you to come forward.
I need your name and title.
Okay.
Melissa Curry,
C-U-R-R-Y.
Currie, and I'm Senior Planner and Project Manager at Dewberry Engineers.
Thank you.
All right, sir, if you'll come forward, please, and be sworn in. That's okay. We'll get you to fill out one before you leave. The reason we need it is when you go to the Board of County Commissioners, they won't allow you to speak unless they know you spoke here. So we'll get you sworn in and then get you on the record here.
Raise your right hand. Do you solemnly swear or affirm the testimony about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, sir, your name and address for the record, please.
Dave Martin, 7656 Burnside Loop. I'm number, I can't read it, maybe 9. It's next to the pool, if
Okay.
anybody knows. This lot won't really affect me at all, to tell you the truth, but just thought I needed to say just a couple things. I relocated here to Pensacola, and when I came here, there was a variety of places to go, but I chose this subdivision for 2 major concerns. One, and again, I know factual, you want factual, and I know that D.R. Horton gave me a packet of stuff that I'm sure covers what they're doing. But it was intended for a 55-plus community. That's what was told to us. We chose that lot by the pool. My wife didn't want it. The salesperson laughed at her, saying, you know, because kids and being at a pool and the kids and the noise and things like that. And the salesperson said, don't worry about that. I don't think you understand what this community is. It's a Freedom Home geared towards 55 and older. So we said, okay, and we bought that lot. Since then, because houses weren't selling as quickly as they wanted them, they waived that. And I'm sure in their guidelines, they were allowed to do that at some point in this packet that we got telling us. But the community is not built for a normal community. The pool's not big enough. The streets aren't wide enough for this type of traffic. And I understand it's only 1 or 2 more lots, but the pool is so crowded right now that it's closed half the time because it needs to be cleaned so often, which isn't the developer's issue. But it is that the population there went from a 55 and older, 2 people, maybe 3 people maximum, to now families of 6 is what it's developing into. So the whole gear towards it really isn't what it's being used for right now. It's not what it was told us it was going to be. It was a gated community for 55 and older, and it's not a gated community because one gate's left open for construction that we don't understand why it can't be closed from 7 to 7 or whatever. And now it's not 55 and older. So the original 20, 25 people that live there, already 5 houses are turned over because of that situation. I still love the community. I love the setup. But the population within that now is more than it was meant to hold, I do believe. So I'm saying that there is no utilities run to that lot right now. I walk that loop every morning. And I understand they want to try to fit one more in. I would too if I were them. But to the people that live there, even one more house with 2 to 6 more people is just another burden in there. We have parking on a street now, which wasn't approved. It's supposed to be no street parking. But when you now have families of 6 with teenage kids and kids learning how to drive, there is no place to park in the garages. I've realized in Florida, there's no basements. So the storage is now in their garages. I bought the house with a 3-car garage because I realized that. But now people are being forced to park on the streets. They're not wide enough. The kids on bikes and on their little go-karts and things are causing just a little bit of an issue. I love kids. I had 4 of them. I don't want any more. But the kids in this neighborhood, I tell you what, they really are good kids. I mean, they're not like they're troublemakers, but the open gate for the community has caused vandalism, theft, and different items too, that they keep building this stuff. And we've asked them time after time to close the gates. And if there's a need for some work crew to get in earlier, obviously they could have an employee come and open the gate for them. We're not trying to keep workers out when they want to be in there. But the community's not designed to be this size. It's really not designed to have this big a population in it. It's not what it was geared towards, I believe. So even one more unit would make it just a bigger problem. And that's just my view. I appreciate it.
Thank you, sir. Some of the items that you brought up are not within our purview. Some of that would be more suited for a homeowners association or for the developer. But a couple of things that you mentioned, I know when we do a PUD, there's very specific development comments put in place. any of the gentlemen's comments as to what was approved applicable to this?
Again, the reason why we are here is for that one additional lot is, you know, that was not the original approved plan. They did meet, you know, the requirements of the original development master plan of having a, the amenities such as the pool and the gathering area and having a universal trail that goes all the way around the subdivision, including sidewalks, upgraded lights. Those are just some of the, you know, things that were proposed at the original PUD, and they have completed those. They would not get Phase 3 approved until all those were done, and they have met those, you know, obligations of having that done.
So something like that the developer initially said that it was for 55 and up community, is that something that can be limited in a PUD?
That was not part of the packet of the PUD when it was first submitted to y'all. You know, we were told through DRC, this is supposed to be more of a, there was no number in their application, their submittals, it's just part of their narrative. You know, staff has heard those type of things as well.
Okay.
That's the reason they said they wanted smaller lots. This is a more unique with Antietam. They provide sprinklers and mowing for all their lots already. So that was kind of the reason why they did that as well, was to help provide those, so the elderly don't have to mow their lawn, it's already taken care of for them. So that is, they have a highly HOA fee, what I've been told and stuff like that, due to take care of all these other things that normal subdivisions would not do.
Okay, and he mentioned the width of the road.
Those are just standard widths that meets county standard. We don't, they just have to meet the county standard. We don't review that in the PUD. If they
Okay, so
wanted a width,
there wasn't anything that would be allowing a narrower road in this subdivision?
no, this is the minimum as all subdivisions are approved through the county that is allowed.
Okay, and he mentioned that it was intended to be a gated community, and I was under the impression that the county didn't assume responsibility when it was a gated community.
It's a private subdivision, so it is gated. The front gate is working now. I do know the north gate, which where's they let the construction crews go in through that north gate. That is between the HOA and D.R. Horton to work that out. That is something that we cannot get involved in.
Okay, so just about every issue that the gentleman brought up is really more
Through the
with
HOA.
the developer and the HOA than with the county having some enforcement over those things.
Correct.
Okay. Questions? Tim?
I just want to, one more time to be clear. In the PUD packet, there was no specification for 55 and older, correct?
No, there was not.
Okay, it's a passion of mine. Yes, ma'am.
I have the document with me, can I read from it?
Yeah, we have to give her.
Sure.
Yes, ma'am, come forward. Again, just state your name so we know who's on the record,
Yes, sir.
please.
Melissa Curry. Pardon me. I'm sorry, I'm a little froggy this morning, with Dewberry Engineers. So I do have the PUD document that was submitted with the original PUD, and it says the first phase, the reduction of lot sizes is to allow for clustering of dwellings on smaller residential lots to protect prime farmland from non-agricultural use or to conserve and protect environmentally sensitive areas, as stated in Section 3-2.5 Low Density Residential District. So it was not ever stated that they were for age restricted. And there was not anything stipulated in the PUD document or narrative regarding a gated entrance as well.
Okay, I just wanted to make sure it was on the record. It's a passion of mine to actually bring a product that is sorely, sorely missing in our area for this. But typically, as a past developer, what will be on there is need not be built. And there's a very good reason. It's not because developers are terrible people. It's because of the incredible risk that they take. And I get that. And they would also probably tell you that the narrower streets are traffic calming. I have a subdivision. They're very narrow, and it does work. You have to go slow. And I hate that. I just wanted to make sure. I doubted that we could. Typically, they'd say they market it towards 55 and older. But it is a product we sorely need, but that's another day and
Right,
time.
and the roads were not, there was not a stipulation for narrower roads or anything like that. As was pointed out, they meet all of the county standards.
So it's just 66 foot wide, would that be?
I believe 55 for
55.
these small subdivision local roads, I believe it
Okay.
is. Yeah, most of these are in their bylaws and HOA covenants restrictions. In their bylaws, they usually say that they have the overall control of the master plan. If they want to modify it, do any other changes, that is in their bylaws through, as I've read through plenty of times.
Eric, did you have something?
I have a real quick question for John. The 55-foot roads, that allows for parking on both sides. I lived in a subdivision where the roads were narrower and parking was prohibited because for fire, they couldn't get through. So there's no restrictions on parking
So,
on both sides?
There is no fire restriction for parking or anything like that. The county does allow for the parking, but this is a private subdivision. So with most D.L. Horton subdivisions, they do not allow parking on the side street for more than like 48 hours or 72 hours, especially for homeowners. Now for guests, it's, there's no parking police that, drive up and down this and that. This will eventually come at HOA once they take it over. Right now, it's still under D.L. Horton's control until, I think it's usually 80%. Once built out, then they can form their own HOA and they can enforce it how they see. But right now, D.L. Horton's, I live in one of them, their subdivisions, and, once a month, someone might get a, hey, email, everyone gets an email, please do not park on the side of the street for more than so many hours. But that's just the way, there's no control, and these are private subdivisions. So if they do, then it comes to the HOA for how they want to figure it out.
So just one more time, so to add this additional lot, what is being given up?
It's just the additional lot. They've met all the amenities that was first presented in the PUD. If the board sees some other, what can you do different? What can you add more for this one additional lot? If that's something they want to see, that's up to the board. They've met they're meeting the same setbacks that was required from the original PUD. They're just adding one additional lot, which would be shrinking a park down by 52 feet, as you mentioned before. And the park is, they don't have any plans to do anything such as put a playground on the park. It's basically just an entrance path to get to the main trail. That's what it is, an open space area.
So there was no requirement in the original PUD for the size of the park. Was that a concession that was made to allow for the PUD?
The original size, which was approved by the original master plan. So we are shrinking, so that's what I'm saying. We're shrinking the park from the original master plan and adding an additional lot. That's why we're here today, because we have now shrunk the park by 52 feet and add an additional lot. That's why we want to bring it to the board, because it's a change.
Right, and this, and if the, and the park size and all that was in there, that's part of one of the enhancements for a planned unit development. That's why we came back, that's why we told you gotta come back to the board. If the planning board so wished that, wait a minute, park size, that's what's a guarantee, that size, that use, you are shrinking about 52, that's a decision that you all could make, and either you approve it to go further, or you say, parks are good. It all depends upon your decision, so.
But as I understand this park, we're not talking about what we would envision as a park with playground equipment or picnic tables. We're talking about an access to the walking path, is that correct?
So, yeah, currently that's what it is, but it's from the original master plan. It's a larger size than what they're proposing today. So if the HOA, when they take it over, the community wants to do something with that open space area, that's for them to decide how they want to spend their HOA money. So this, we're going out of the picture here, kind of what this is about, one additional lot. Do you approve an additional lot in a smaller park? That's the question today that we're just trying to resolve.
Would it be okay if you zoomed in on those in that area? Because what I'd like to point out is that although that park area, we're talking about it being made smaller, you can see that there's another park added here to the southwest, and then there's also that additional strip, the ECUA area. So that's why these lots are shifted over. And although we're saying that park is being reduced by a certain width, there was additional open space that was added that is equivalent. It's the same size. So If you also could zoom in around that table to see what the total open space percentage is, I believe it's around 50%.
Ms. Curry, Mr. Pyle had a question. Was the additional open space for the park in Phase 1, or was that as part of this adjustment in Phase 3?
I believe that was part of Phase 1. Let me look at the map. I believe that was part of Phase 1.
It was added over and above what the standard was for the master plan?
Yes, we're well above the required open space and park areas. It's just this shifting that has happened, and then there was that additional access area that was put in. So there's quite a bit of open space
And
here.
the public has access to that, it's not,
That's correct. We're not impeding the public's access with the new lot. Oh, I'm sorry. The people that live in the,
okay,
within
I'm
the
sorry,
development,
residents, I
yes.
said public, but residents have access to this parcel where the easement is for the ECUA then? Okay.
Right.
So if I could maybe break it down in layman's terms, it's a lot easier to draw than it is to actually construct. And then when ECUA and everybody else and start shifting things, and you guys wisely, because you didn't want to end up on the cover of the News Journal as being whatever, I could picture that story right now. You're going to go the right way and correct the issues. That there was some, and in the meantime, since you had to go to the well, I believe the developer said, hey, well, we might as well try to get this extra lot, which I would too. I mean, is that kind of where we stand? Thank you. Okay. I feel, and in the meantime, there's some expectations from end-use customer versus what they had hoped for, and it probably would be the HOA. Unfortunately, advised maybe to get on the HOA and.
Yeah, I'm not sure that the developer came and said, we're going to just try to pick up this extra lot. There was a lot of shifting that happened, and with, as I was saying before, when the development order is issued, it's on a phase-by-phase basis, and so there's a group of lots that get put into a phase, and I don't think that we were always cognizant that there was a one-lot discrepancy. And then once we realized it and we had these development orders in place and the lot, like I said, the utilities and all had been put in the ground, we had to fix it. So I don't know that it would be entirely accurate to say that they were just trying to grab an extra lot.
Well, and not to belabor this, but so if I'm the developer and I go to contract with the site person, was the site developed for 199 or 198 lots?
199, because those are the development orders that we had.
From the very beginning, 199.
The very first with the
Well,
original,
So if I'm going.
from
to-
phase one,
Yes.
with the
was
phase
just
one development order, it was listed as 199 lots.
That's, okay, that makes sense to me
Yes.
now. So there is somewhat of a, okay,
The phase one plat says 199 lots.
Of
okay.
course, we're not picking up anything you're
It-
saying because your
it's-
microphone's not
So
on.
you,
Oh, okay, all right.
so the developer contracted with the site person for utilities, sewer, everything for 199 lots. This in end
That's
also
correct.
cleans up that contractual language, because you have gone to contract with people for
Yes.
199 lots.
That is correct.
Okay, thank you.
Okay. Additional questions? Okay. Yes, ma'am?
I'm one of
If you'll
these that's
turn that in to the staff members and come forward, please.
new to the process, I'm sorry.
Yes, ma'am. If you'll please be sworn in.
Raise your right hand if you solemnly swear or will affirm the testimony you're about to give in this case. Thank you. The whole truth and nothing but the truth, so help you God.
I do, thank you.
All right, ma'am, if you'll state your name and address for the record, please.
Hi, Jane Phillips, 7958 Burnside Loop. Thank you very much for listening to me. I just wanted to have somebody come and take a look at some of the areas that they're proposing to build in. We're losing a lot of sediment and dirt that's going into our detention ponds and retention ponds, and that's not getting cleaned up. I live on the far side over, I don't know what lot number it is. Oh, yes, on that side. And that particular detention pond has raised up at least by 5 feet due to sediment that has been washed in from the lots. And they continue to do the same thing, put in more dirt. The rain comes, it washes away, and that's repeated over and over and over to where now our retention pond has, the level on that is so low that when we get this next storm, I'm wondering if it's going to overflow. The proposed area is right along some river and some streams and such. And if you go to look at it today, what they've done, and I do have some pictures, I'm sorry I didn't print them out, but you can see where the dirt that's been piled up currently, as soon as this rain comes, it's going to wash all down into that area there. So they're not putting up their silt fencing. They're trying to put dirt on top of dirt, and it's washing away. And the new proposed area where that park is supposed to be, there's a huge ditch in there. And if you go to look and try to calculate how much soil you're going to have to put in there and then put a house on top of it, that thing's going to wash away. So y'all need to go and take a look at what they're doing. The trails that are back in there have been washed away. And I don't care if they put in another house, make what you've got developed be able to sit still and hold and get that stability issue taken care of. And that's all I need. Thanks.
Thank you, ma'am.
John, you mentioned it's in DRC or soon?
So they cannot get their final approval for the new master plan of 199 lots. That was never reapproved. The approval was 198 lots. So until the BCC says they'll approve the 199 lots, we can't approve the new master plan. So the new master plan's on hold until the planning board and the BCC come out with their recommendation.
Okay, and these concerns about the retention ponds and soils moving, what responsibility does the county assume when it comes to inspection during construction? I realize that these retention ponds are private because it's a private subdivision, correct? So the county's not assuming
Well, it's still under, there's still checklists that the county will go out and do on a yearly, within the year of final plat. There's still Northwest Florida Water Management District that they'll have to comply with a year, 2-year agreement type of deal. They'll come out and inspect as well to see. There's been plenty of it with all the rains, and when they do construction they're not just clearing 1 or 2 lots and building a house nowadays. They're pulling all their permits for about 10 to 15 houses at once, clearing them all, and it's just basically like being in a car factory, just moving down the line. Each, type of, whether it's masonry, whether it's plumbing, building the home, foundation, they're just doing one at a time. They get in there and, knock it down pretty fast. So, whether silt fences aren't being put up, they can call the county inspectors and make sure that there is enough silt fence to control any erosion. They are to go out there and clean up as inspectors see that. We have the public, the private citizens, be welcome to call Planning and Zoning Development Services Department, get hold of their inspectors to come out. We will try to resolve the issues as much as possible, but again, it's really on the builder to keep that place cleaned up.
Okay. I'm not necessarily opposed to the adjustment in the master plat, but something like that where retention ponds are changing from what their original engineered plans were, that's a concern because it will cause water problems. And folks that live in the neighborhood, you've heard them, you can call out, is it code enforcement or who would they call to make sure that it's inspected properly?
What they need to do is that you can get with me, and I have my site inspector, Mr. Kevin Blanchard, to go out there and take a look at it. Again, it is a private subdivision, and we would get with the developer, Joe Horton, whoever is to make sure that they get these erosion controls back in place, because that is very, very critical, because it can impact the county permit as well, our national stormwater permit that we do have. So, but we would definitely contact me. Let me get with you afterwards so we can get them to see.
Filed with Officer Beasley. There's already a complaint on file.
Yes, and I will get but contact me because I have an inspector, Mr. Kevin Blanchard. I don't worry about him. If we get on top of it, things can start moving very rapidly.
Yeah, I would say it's a great idea because typically, here's the gap between not only just production building, but what happens is afterwards, guess what, HOA, you're responsible, and even though that pond was calculated at X% deep, you have to clean it now. And nobody on any HOA ever knows that. And years later, until it fails, is when you go, wait a second, and they say, well, it's, you know, your problem. So I would think prior to the final CO, it'd be awfully nice as I walk through that those, you know, like you said, for NPDES, I mean, that's a big deal. To hand over a subdivision, if it's 5 feet, I would hope that that's, I hope that's not accurate, but, you know, who knows? So that's the whole point. We don't know, and it should be, I guess, before they punch out, say, thank you, it is what we said it was going to be, have a good day.
Right. And like I said, and it is a private subdivision, and sometimes they have their own type of regulations and protocols and procedures, but staff would definitely see what's going, and check with them.
But the
Try to reach
developer, is on that HOA right now. They are the primary HOA.
Yes, they are.
They can't do a thing about it. But guess what? When they turn them all over, they're out.
Yes, they are.
And so there has to be some accountability at that point, at the end of, prior to their taking leave of the HOA, that they, when they hand it over, there should be full disclosure. Hey, by the way, you also have all these other things to take care of. Not only the rules about the pool and the parking, those are, you know, certainly important, but
Absolutely
the
right.
big chunks are, you know,
Yeah, at this point, the county, since it's private, the county doesn't have too much of a pull in this. So it's the state, Northwest Florida Water Management District, who is really oversees the ponds now.
But the county has oversight in that it must meet with the construction plans that were turned in, so it's gotta,
It met it at the final plat stage. Now with the construction of building homes, if anything's really impeded, we can go out and notify them and try to get them to do whatever they can to clean up. And we give a yearly, basically synopsis of anything that might have broken, failed, or is looking to, you know, torn apart. Give them a list of what they're to do, whether they do it or not. We cannot force their hand. Again, the Northwest Florida Water Management District is really their contact this point forward when it comes to the ponds.
okay. All right. Board members?
Okay, just to clarify the numbers, the PUD was approved for 198 lots in August of 2016. In May of 2017, an additional lot was added in the, through the development orders process in Phase 2.
To Phase 2, which we still met their number, their master plan numbers.
But in the timeline, you're showing it going from 198 to 199 in that process.
So until we got to Phase 3, it's not an issue because, you know, if they wanted to add an additional lot to Phase 2, that should have been approved at the time, and that was something that I believe on staff's level was, you know, kind of missed. So it was a two-part thing. Staff missed the Phase 2. In Phase 3, we had ECOA, which caused another conflict to shift everything down, for they lost basically another lot, and they're trying to gain that lot back and get an additional lot. So that's what we're all trying to work together to fix all these problems at once. Again, the master plan was stuck in there. They thought there was approval, but it was a misconcept of, we weren't reviewing the master plan thinking it was the same master plan. One little lot didn't stick out to the reviewer that was seeing it at that time.
So they gained a lot
In Phase 2,
in Phase 2 in August of 2017.
correct, from the construction plans. But on the master plan, it did not show that, and that's why we're saying we need to really codify this, fix this, for everything matches up the way it should be from a new approved master
So
plan.
it's a developmental services error.
Well, it's kind of on both, because when we got to Phase 3, ECOA asked it for a 15-foot, which was not part of it, so that's when everything started getting caught up and catched. I mean, they were still meeting the lot numbers in Phase 2.
Well, 198 is the lot numbers.
Yeah, they couldn't go over that. Once we realized, oh, you might be going over that or losing a lot, that's when we really want to codify it. We could simply take a lot away from Phase 3. You know, you're approved for this many lots, whether you put an extra one in Phase 2 and take away one in Phase 3, you still meet 198. But the fact that now they had ECOA easement needed, that's where they really lost a lot, and now they're trying to gain that lot back because of the ECOA easement, and they want to add an additional lot on top of it.
So they lost a lot from the county's error. The
But
county
they also
ga-
get,
the
but they
county
also
gave
gained a
them
lot in
one.
phase two. That's what I
Got
said,
it.
this is, we've gone round and round, doing the math 5 different ways, trying to figure it out.
So
And
one
once-
ninety-eight would still stick to the original PUD.
198 sticks with, that's what's approved right now, but they're looking for one additional 199.
I hate to keep coming back to the same issue, but we heard testimony from the representative for the developer that they submitted the master with 199.
It was not submitted as a master plan. The sheet was stuck in there in the construction plans, which is not the master plan development order. The master plan has its own development order. So the master plan was never approved for 199. It was a sheet that was just inserted of what, basically kind of what they wanted to do. You know, and that's something where we all missed, they didn't understand that process. The reviewer kind of missed that part too, so development services missed up on that part where we said, hey, hold on, you're adding an additional lot, let's, you know, it showed phase two with the additional lot, we're fine. But we did not understand with the ECOA easement what would come in conflict with it of everything shifting down when they did the shift. So it's been a very ongoing Scrivener's battle
So
trying to
those
figure
de-
the best way.
Those plans were submitted
In the
initially?
construction, and they were submitted, one sheet was submitted in the construction plans. This sheet that you see in front of you was submitted in the construction.
I'm just trying to get to the timing of that sheet. Was that put in initially? I understand that it wasn't the actual master plat plan, but the timing of it, was it submitted with the original package?
No, not this master plan,
Okay.
not
There's
the
a,
original
there's a
package.
timeline included.
Yeah, the original master plan was approved with original PUD in phase one. And phase two is when the construction plans showed the additional lot in phase two.
And let me say something. I mean, we can go back and forward and keep on coming back. This, and when the first meeting that I had with them to discover this challenge, very, and they were there was some, they took there and said, wait a minute, we know what we did, and it was a very complicated process of trying to pull all of the pieces together, all of the parts in the timeline. So if there is more that you want to hear to try to really, so you can make a sound decision, we'll go back and we'll try to break it down a little bit further. Because I do not want it to be put out where it's development service area, because this, what occurred is so convoluted. It's extremely, where we got to put old plats and go back to 2016 and put, so it's a very convoluted process, very convoluted details. So, but if there's some questions, because I had the same questions, believe me, we had to have several meetings before we can get down pinpoint to bring it to this point. So if there's still not some hesitation, it's
Well-
probably best to step back until we could really make y'all clear so you can know what you really is expected to do. It's
Yeah,
Mr.
and
Chair.
if I may,
Go
ahead.
can you pull up on the document that shows the timeline? I just want to point out that the original master plan that was submitted was a conceptual master plan. So it was conceptual, it was loose, it didn't have dimensions and things like that on it. With each development order that we requested, we submitted an actual master plan that had dimensions, that had been calculated, and and that master plan each time showed the 199 lots. I don't know how this difference happened, but if you can see here, the development orders issued going back from 2016, then 2017, and 2018, we received approval to build 199 lots. And so it was spread out over time, and with each one of those development orders, those lots were installed and built in the utilities and all. So these things are in the ground as 199 lots. And we're just super appreciative of the staff working with us, because we get confused too. And so we're not exactly sure how this discrepancy happened. And so we would really like to just settle it and move on. Let's, like, it's been ongoing for quite a while. So we would really, really appreciate it if y'all, we're not trying to say, hope that you don't understand what happened, but if we could try to resolve something today would be great. But I think that this timeline is helpful in seeing sort of the breakdown. This is just sort of the nuts and bolts of what has transpired.
If I may, yeah, this is the nuts and bolts when it says development orders issues, those are for the final plats. So when you look at the preliminary plat and construction plans, that's where the little minor mistake happened of additional lot, or the preliminary plat has one, but the construction plan has two, additional lot. So that's where, as I say, this is a lot, we'd have to pull up the preliminary plat, construction plans, and we can show you each number of those, what was approved, this and that. This is the final submittals, which really matters. But what happened was behind these, the other development
Right.
orders. And that's why it's like, we're trying to keep it as simple as possible. It's one additional lot, shrink park, simple. I think that's what we all need to look at, is
Right.
whether you approve that or not.
And the phase lines sometimes shift because of construction. So sometimes we put the phase line in, and then when they're trying to do the construction, it makes sense to stop the construction here, and that doesn't exactly align with where we thought that the phase line was going to go. So that's why sometimes phase lines shift. But really, this is an extremely minor change. And if you think that it's still consistent with the intent of the PUD, we're not increasing density, we're not asking for any additional infrastructure, we're not changing any of the design, we're not changing any of the engineering. There's no impact to the runoff with this additional lot. It's just because of the way that things shifted in that Block M, moved it up, and we had a certain number of lots that had gotten utilities and platted on the ground. And it just sort of happened because of those two, the ECUA easement and then the access easement that was put in the middle. So that's how it all happened.
Okay.
Thank you all.
Thank you.
Mr. Chair, I would also, I have to say, in the process of this with the construction phasing, a development order was issued, somebody went to contract in full aware, or I think, honestly thinking 199 is what they went to contract with. They weren't trying to pull one over in the county, because if they had had any idea what this would cause, there's no way they'd ever want to come through this process again. You get the DO, you get your plats recorded, it is high five, let's roll. And no, they're not. In fact, for the grievance, I think what they're really trying to do is make their subcontracts true out with their lot numbers. Otherwise, you owe me $47, or whatever. It's just from a perspective of that side, I believe, as much as we wish to deify developers, or some folks do, or the opposite of deify, I'm sorry, but villainize them. I really doubt that there's a lot of, sleight of hand here. In fact, I think just the opposite. Because they're bringing it out in the light, we're going to ask all these questions and spend 2 hours trying to wrap our head around something that I'm not going to be able to really understand, other than the fact that I'm pretty sure that they're not trying to get over on this. But that's my
And this
take.
is the thing I like to add, Mr. Powell, and eventually, the commissioners gonna have to make this decision, because they're the one that got to say, yes, we want this to happen, because at the PUD process, there's a record on what the commissioners expected and what they wanted to see and what they wanted. And it's laid out in the previous record for the Board of County Commissioners. And as Mr. Powell stated, we just don't want no one to leave and to try to vilify no one, but understand that there are some challenges and some changes that occurred. So, and that's the basic question. Do this planning board make a recommendation for them to basically, if you feel like they have gotten all the enhancements or the amenities from the original and none of that is increasing or diminishing, the recommendation can be go forward and let the board basically see if they want to get into more details on what actually occurred.
Good. Eric, did you have something?
At the end of the day, 199 would have, prior to missteps or oversights by different parties at different times through the approval process, 199 would have been approved originally, because all of the metrics of the plan meet compliance. So if just go back in time, and if everything had been submitted right and no one had made those missteps, 199 would be compliant and would have been approved.
That's very much so, you know, to the board, so if they think 199 is no different than 198 a whole lot. I mean, you just think of this as being the first PUD meeting, you know, would you approve this PUD meeting?
So I think it's very important how it's presented to the Board of County Commissioners. Communication is everything in this, because if you say, I like it, because you're checking it, you were testing it. You didn't want to say too much, but it's too late now. Pandora's out of the box. So, I mean, it's the reality, because this is a great testing ground, because in front of the county commissioners, you're going to have to present it in an orderly, logical, confident manner to where, because if we don't get it, I mean, we read it. I read the timeline, and I thought, well, I earlier stated, which was a little off, what I thought was happening, and I don't think that was accurate now. But moving on, I'll let the chair.
Okay. Any additional questions from board members? Okay. Ms. Curry, did you have anything else to add to the case?
No, just thank y'all so much for your time.
Okay. Staff, anything else to add to your case? Chair will entertain a motion on item 6B.
We're going to have another speaker if you want to give him a moment.
Okay.
Just so that I can speak at the county commission.
Okay.
And I think the first gentleman wanted to, he wanted to.
Okay. Board members, hold on just a minute, sir. We're going to need a recommendation from someone on the board, because as you know, we typically give individuals the same amount of time. If you would like to bring them back up, you're allowed to do that, so.
I recommend additional time.
All right. Sir, come forward, please. I'm sorry, it's just kind of our
No problem.
our rules
No
here, you know,
Well,
we,
I just kept hearing about the reduction of that park.
hold on just a moment. Go ahead and state your name and address again for the
Dave
record.
Barton, 7656 Burnside Loop.
All right, go ahead, sir.
We keep looking at that and saying there's a reduction in that park. That park really is just a pile of woods. It's just woods. And 52 feet or whatever that would eliminate that. I wouldn't reduce it. We're not talking about a huge area. We're talking about 52 feet would take it all the way to the trail and all the way to the retention pond. So if you haven't been there, it's not a huge wooded area in this little square that they're showing. I mean, it would eliminate all those woods and take that house or whatever all the way to the retention pond that is 16 there, where there is no issue right now in that retention pond. So it's not really a park, it's a wooded area that would eliminate it.
Okay. Larry, come forward, please.
Raise your right hand, sir. Solemnly swear to testify about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Larry Downs Jr., 12156 Habburg Drive, Pensacola, Florida. As you know, we have to get up here so we can go speak at the next meeting. So that's what I'm doing. Thank you.
Larry, let me just make sure you understand the rules of the chamber. You can't add any new evidence when you go to the Board of County Commissioners. So if you have something that you want to say, it has to be on the record here, because they won't allow you to add new evidence at that meeting. It's all got to come through here first.
Will they allow me just to, don't I get to speak just to?
Mr. Larry, you will be able to say your name if that's all you want to say. This is the same, it's quasi-judicial rezoning. Ms. Rogers, she's gonna have the exact statements, what was what, because it's all quasi-judicial. So if you don't make your comments here, Mr. Brisky is correct. And the attorney can confirm that, Ms. Kerr. But this is a quasi-judicial process.
And that's exactly why we have the court reporter here recording everything, is because they do look at the transcript before it goes into the BCC. So it's got to be put on the record here, because they won't take new evidence there.
All right, well, I'm for it. So that's what I'm gonna get up there and say, and all the reasons I'm for it is because they are requesting it. It's their property. Thank you.
All right, thank you, sir. Okay, anyone else who hasn't already spoken that wishes to speak on this matter? All right, public comment portion is hereby closed. We'll ask the board members for any additional questions or discussion. If not, Chair will entertain a motion.
I'll make a motion to pass Z 2021-05 as requested.
Hold on,
with
that's the wrong case. That was,
I'm sorry.
that was
So
the previous
2025?
one. It's the public hearing,
Oh,
6B. item
Sorry, it's the
6B.
public hearing. I would make a motion to approve the public hearing for the increase or the addition for the Antietam PUD with special note of process of handing over community to the end users and how we walk out of that. I don't know how to say this.
I mean, would it be the final inspection would be per the construction plans that were submitted or something like that? I mean, is there anything like that?
Honestly speaking, I don't think that's a separate item. It's a separate process because again, a scamming account, we're gonna automatically do that anyway. But perhaps maybe with some attention to the stormwater for the county to look at it, not make a condition, but directing staff to really look into those things that was addressed. Because you can't tie those two, I don't think you can tie those two.
So there's a couple things I'm trying to achieve here, because the homeowners have a little leverage right now, and I want them to be able to use it, quite frankly. And for the right reasons, not just to hold it over the developer, but for them to actually deliver what they said they were going to deliver. And I think there's a gap in our process where I don't think that we're able to inspect it. And if we are, then we should be doing that. And then I'm just talking for no reason, but we should, when we hand it over to the HOA, it should be the way it was on the plans. And from what it sounds like, it may not.
Yeah, I mean, we're gonna have final inspection. That's part of the process, and we're going to give that to the developer, and try to, again, there's some rules that are different when it comes to private. So, but we definitely gonna do our due diligence like we always do. Follow through, definitely.
Okay, so what I'm trying to do, I guess, is give the BOCC the ability to hand them some more leverage, I guess. I would like to go ahead and make a motion to approve the public hearing, and I would like to request that the Board of County Commissioners pay attention to the final, how do I want to say it? The final plat as requested in the development order, that it match for the homeowners association. It's clear as mud, like we said.
Okay.
We understand what you're trying to say. Like we understand like we always got to do that anyway. But we understand what you're trying to say.
Right, so let me just summarize, make sure everyone understands. Your recommendation is for the approval of the extra lot for Antietam with a special note to the commissioners that you're asking that they make sure the construction inspections are enforced and that it ends
The
up.
final deliverable product matches what was on
What
the
was-
development order,
okay.
and
All right, very good. You guys got that? So you'll know what the recommendation of the planning board is. All right, do we have a second?
Second.
Okay. Any further discussion? All those in favor say aye. Aye. Opposed?
Nay.
Okay. We have one opposition with Mr. Ingwell voting no. All others in favor. So the recommended order from the planning board will be to approve with special note to the commissioners as noted. So, all right. With that, we don't have anything else for the rezoning hearing portion of the planning board today, quasi-judicial portion. So we are adjourned. We're going to take about well, let's just go ahead and take about a 5-minute recess to give them a chance to reset the cameras and the recording devices. So, all right, we are adjourned.
You just cracked
know that's horrible. Eating McDonald's. Ain't that crazy though? That is crazy. All my clothes are too big. That's a good problem. Yeah, but now I never know what's weird. Like, big pants. Yeah. And it's like in between sizes. So like.
Hey, do you think they'll really stop me from saying stuff down at the county commission?
Definitely.
How much time do I have?
They're definitely gonna
Now,
stop.
you telling me that I can't have whatever time you allow everybody
It has
else?
to be on the same topic that you discussed here.
Yeah, which is property rights, so it just expanded it hugely, didn't I? I expanded it hugely.
We'll see how Allison handles it.
Like, oh, this is relative to property rights.
Because they all read the transcript before the meeting, so they know who discussed what.
Yeah, well, the rain held me up this morning. I've been here for 12 months too.
Yeah.
So I didn't have time.
I feel like they have an expectation though, when they see Larry Downs Jr., they're like, all right.
I haven't been here for a while. I promised, I told you I'd leave you alone for a good while.
Yeah,
It's been a good
everyone
while.
says you got quiet after the alcohol ordinance was approved.
I told him I would quit.
You did for a while.
I said a good while, I didn't give it time. And I've had several people say, even like 2 months ago, it's been a good while, Larry. It's been over 2 months. I'm like, no, a good while, I think would be maybe midsummer. Cause that was like in February, 1st of February, so.
Yep.
Midsummer, that's a pretty long time.
This year is flying by.
It is, every day is.
July.
Well, when you work every day, you know, it kind of.
I've never seen time fly like it is now for me. I remember it took forever to get to 30. It took forever. I was like, Jesus, this is crazy. I want to live forever. Went from 30 to 52. Man. That was amazing. I was 30, I was 34, I was 38. It's like,
Please stop.
it's like, what the heck? Then I was 42.
It's all downhill from here.
I was 45. Then I was like, what? How is it going so quick? The only good news is if you eat a lot of junk. All right, everyone, we're going to come back into session. All right, Rachel, are we ready? I think, okay, all right. All right, good morning, everyone. Again, we're now going to call to order the regular planning board meeting for July 6th. And on this meeting, have we had proof of publication?
Yes, sir.
Okay, Chair will entertain waiving of the reading of the legal.
So moved.
Motion.
Second.
Second. All those in favor say aye. Aye. Opposed? All right, we will come back to our follow-up reports and outlook. At this time, I'd like to ask members of the board to accept the planning board meeting and the findings of fact into evidence for this hearing.
So moved.
Motion, do we have a second? Second. All those in favor say aye.
Aye.
All right, the planning board hearing package and the findings of facts will now be entered in for July 6, 2021. And we'll go directly into our public hearings. The first public hearing is a public hearing concerning a review of ordinance amending LDC Chapter 3, Section 3-2.4, Rural Mixed Use District. This is increasing the retail sales gross floor area. That the board review and recommend to the Board of County Commissioners for adoption an ordinance amending the Land Development Code Chapter 3, Section 3-2.4 for increase in the retail sales gross floor area allowed in the rural mixed use district throughout conditional use approval. Who's going to be, all right, Drew, good morning.
Good morning, Andrew Holmer, Development Services Department. I guess the best way to explain this, the county has 3 mixed-use districts: rural mixed use, low-density mixed use, and high-density mixed use. All 3 of them have this 6,000 square foot limitation in the straight-up allowed retail uses as far as the size of the building. LDMU and HDMU have a conditional use option to go larger than that, and it calls it out as medium scale. It goes up to 35,000 square feet. For frame of reference, your freestanding chain drug stores are, 11 to maybe 15,000 square feet in size. Your dollar store type uses are around 10,000. There's no option at all currently in rural mixed use for anyone to go to anything larger than 6,000. Over the years, numerous people have come to us and, we've had to say there is simply no option. So what this is we were requested to look into amending the code for rural mixed use to allow a conditional use option, but we're only requesting that it be allowed up to 15,000 square feet. Because this is the rural areas, we don't want to bring in really big retail type uses into those areas. So that's it in a nutshell. Just a request to provide a conditional use option to go up to 15,000 square feet.
And I know the conditional use goes through the Board of Adjustment, but what type of things are they looking at when they would consider a larger number? What are they typically considering?
So it's specifically, mostly, related to compatibility with the surrounding area. What sort of traffic is going to be brought in? What sort of impervious surfaces are we going to look at? How much of that? Making sure the stormwater is handled. But for the most part, it's about compatibility with the surrounding area.
Okay.
This says specifically retail sales, but is it other commercial, like offices?
It's, what I did was copy it the exact same way it is in the other mixed-use districts for
Okay.
straight for retail sales.
So not doctor's offices, dentist offices, no service-oriented businesses?
Generally, you wouldn't find those needing to go up to that size unless they're doing a big clinic. Rural mixed use isn't necessarily the area you'd put a large clinic type facility.
A vet? A veterinary office, things like that?
Not that large.
Okay.
Not in, my experience, we don't see them that large. Yeah, they'll have a larger outdoor area if they've got kennels and whatnot, but not something generally we'd see larger than that 6,000 square feet.
Okay. Any other questions, board members?
Yeah, is this being asked by, just because you've seen it over time, or is this being asked by a specific user?
So over time, we've had numerous requests. I know that's been more on the burner here lately, and that's why we were directed to seek if we can make a change.
Okay. All right, Larry has signed up to speak, so we're going to give you opportunity. Go ahead and state your name and address for the record, Larry.
Larry Downs Jr., 12156 Havburg Drive, Pensacola, Florida. Y'all make me do that every time just to see if I can still remember where I live.
Got a lot of eyes out there watching you on the camera so that, we're trying to make you famous here, Larry.
Come by and see me. So this is an expansion of what you might consider freedom. Is that correct, Horse?
Larry, I'm not going to get into your dialogue and those particular statements like that. I'm not going to get into those statements like that.
It appears to be an expansion, a little expansion in freedom. So, yeah, I would recommend, and I am for anytime you can expand somebody's options. Y'all have heard it plenty of times. Our prosperity is linked to our property rights. Y'all know this. Anybody who studies, the history of this country and other countries, property rights is where the prosperity came from. Of course, all them other rights are important too, very important. That's kind of how you secure your property rights. But anyways, I'm for this, and I hope y'all will grant a little bit more freedom here. Thank you.
Thank you, sir. Anyone else that wishes to speak on this one?
Isn't that sad? I just said I hope y'all will grant a little bit more freedom. It's sad, isn't it?
Anyone else that wishes to speak on 5A, public hearing? All right, we'll hereby close the public hearing portion. Drew, anything else, or staff members, anything else on this one? All right. Chair will entertain a motion from the board unless there's further questions or discussion.
Recommend to approve 2021-2509 as requested.
Okay, motion, do we have a second?
Second.
Second, all those in favor say aye. Aye. Opposed? Motion carries unanimously. All right. Item 5B, a public hearing concerning a review of ordinance amending the future land use map, small-scale amendment 2021-01, that the board review and recommend to the Board of County Commissioners for adoption an ordinance amending future land use map for small-scale amendment, SSA 2021-01. All right, who's giving us the background on this one? All right. Good morning. If you would please state your name and position for the record.
Good morning. My name is Kimberly Wilson. I'm a Planner 2, Urban Planner 2.
Welcome.
Thank you. So this one is to allow, it's a small-scale amendment to change from future land use commercial to mixed-use urban. The property, right now, it has single-family residences on it, and it's vacant. Portion of it is vacant commercial. The adjacent properties next to it has professional offices, retail properties on the north side of 9 Mile Road and west of Pensacola Boulevard and Highway 29. So the parcels to the south and east currently fall within the commercial future land use, So I'm just going to go straight to all of the findings for us. So the first one is the Land Development Code Flu Map Amendment Requirements. The analysis is a conversion to the mixed-use urban would provide a mix of residential uses. The change would remove the commercial flu-based restriction on the subject parcel that allows residential development only when secondary to commercial development. This flu change would allow a maximum residential density of 25 dwelling units per acre to be obtained. The amendment also proposes a replacement of flu that allows the residential density of existing commercial zoning at 25 dwelling units per acre while remaining consistent with the surrounding properties. Mixed-use urban as the existing future land use for the parcels located to the north and west. Outside of those immediately adjacent to the properties, the proposed change of the flu of the current flu to mixed-use urban would be appropriate for that parcel, for the subject parcel. The proposed amendment complies with all 4 conditions established by Florida statutes 163.31871 for the adoption of any small-scale comprehensive plan amendment. And you'll see A, B, C, and D, they all comply with that. Housing, other applicable comprehensive plan objectives and policies, housing. The proposed mixed-use urban flu is a suitable replacement for the existing commercial flu and is consistent with the flu of the largely residential and surrounding uses development. Mixed-use urban is the flu for much of the land surrounding the subject parcel. The increase in growth of the area, the flu change would be appropriate and not premature for the area or contribute to sprawl. The application includes documentation of general adequacy of potable water, wastewater, and solid waste services. This site is located along a collector roadway, 9 Mile Road, and a local street, Fowler Avenue. Emerald Coast Utilities Authorities, ECUA, will provide potable water distribution and sanitary sewer collection and treatment and solid waste collection and disposal for the subject parcels. Transportation and mobility, traffic, TTO staff, they review the small scale 9 Mile Road and Fowler, and She listed her comments below, Ms. Terry, if you want to read through those. And then we go to protected resources, wellheads. The parcel is outside of any wellhead protection area based on our county GIS system. Historically significant sites. The applicant provided a letter from the State of Florida Division of Historical Resources indicating no presence or absence of historically significant sites, as these parcels are already developed as single-family residential and vacant commercial. Prior to any future development order, any and all historical analysis must be completed. So then we go to wetlands and habitat. There are no indications from the available National Wetland Inventory map that wetlands are on the subject parcel. If any protected trees are located for future new development, they will be analyzed for compliance with all applicable environmental regulations prior to the issuance of the development approval or the development order. And I believe that's it.
Okay. Board members, any questions for Ms. Wilson?
I will say, Horace, that Miss Kim needs a promotion. As a customer, a consumer, a long time ago, Miss Kim was absolutely the best. She would help guide me through this land-mine field of stuff. She would kindly tell me to go home when I did not have my act together, and diplomatically, and for whatever reason, when she was serving time in planning review, she had to deal with me all the time, and she was wonderful, number one. Number two, on the very beginning of that, you'll notice a name, James W. Pyle. There is no relation whatsoever. I do have a brother named James G. Pyle, who would not be like to be called an attorney, no offense, Kia, but anyway, there is no relation there whatsoever.
All right, well, thank you for that.
All right.
And since you said that, yes, Kim, she recently was been promoted to a planner too, and we are proud of her accomplishments, and we do expect great things out of her. She is a rising, shining star. The Development Service pride ourselves on always giving opportunity to our staff to succeed. I don't want to say fail, but it's on them because we always open up the door.
Very good. Excellent. Thank you. We have a speaker. Actually, we have a couple speakers. Ms. Meredith Crawford. Good morning.
Good morning. Good to be back. Meredith
Yes.
Crawford, 125 East Intendencia Street. Here on behalf of the property owners and applicant. We agree with staff's findings. I appreciate them working with us through the process. We are asking that you change the future land use category from commercial to mixed-use urban. It is a downgrade of intensity. You know, we take no exception with their report and ask that you recommend approval, but I'm here, as is the developer, if you have any questions.
Okay. Board members, any questions for Ms. Crawford? All right, that was easy enough, right? Mr. Downs?
I'll be like that.
You know the drill.
Larry Downs Jr., 12156 Havburg Drive, Pensacola, Florida. I'm, of course, for this one here. Kimberly is great. She's helped me out a lot of times dealing with this nonsense, but it is what it is. But occasionally we get a little more, you know, a little more options here, which is good, and I'm for this, so thank you.
Thank you, sir. Anyone else that wishes to speak for or against this matter? All right, hearing none, we'll close public comment. Anything else
Yeah.
from staff? Okay, Reed?
I want to say, just ask a question. Can you look at the aerial map for me? And this is just more for specific detail stuff. So on that right-hand side, you see a small sliver going down, which is part of the northeastern property. Why isn't that in a small sliver? See the little, yeah, that one right there? That's a part of that northeastern property. Why isn't that included?
Easement? The gap between
Yeah, the gap between, if you actually go to property appraiser, that's part of that northeastern property. So I was just kind of curious why that's not actually included.
Also appears to have an actual curb cut to 9 Mile.
Could you put up
Right.
the survey? Thanks. Yeah, so that, that is part of that parcel. It wasn't, though, included in on the survey for this future land use change. So that little portion, there you go, was not included in the survey. It is part of that parcel, though.
How would you split a future land use with the same parcel? How would that work? Would you?
Normally, we don't want to see split,
Right.
either split zone or split flu. That is just a tiny remainder piece, and it rounded off the property as far as the flu category, instead of having just that sliver down in there.
Because that's access, it looks like it's access to that back property. They don't look like there's
Yeah,
any other
it,
access to that
it
back.
couldn't be anything other than that.
Okay.
So there really wasn't a need to change the flu on that. It's not like that could be developed.
Right.
That little sliver.
Okay.
So we didn't have an issue with it.
Okay, I was just curious how that happened.
And just for clarification, Meredith Crawford again, that's not intended to be part of the development, and they do plan to deed it away, or it would become a separate parcel, so it's not, ultimately it won't be, part of a parcel that's split zoned, it would, or split flu, it would actually.
So you're gonna sell that piece of
be its
property
own.
off and-
Correct, and so that's why it's not included in the plan or the application.
Perfect.
Okay. Paying attention to details down there. Very good.
Every now and then.
All right, any other questions by staff members? Board members? All right, Chair will entertain a motion on 5B.
Make a motion, we approve the amendment to the flu as applied for in 5B.
All right, thank you. Do we have a second?
Second.
Second. Any further discussion? All those in favor say aye.
Aye.
Opposed? All right, motion carries unanimously. All right, move into 5C, a public hearing concerning the review of an ordinance amending Chapter 7, Policy Flu 1.1.1, the Flu 5.1, to provide an amendment to the 2030 Future Land Use Map, LSA 2021-02. The board recommend to the Board of County Commissioners for transmittal to DEO an ordinance amending the comprehensive plan, Chapter 7, 2030 Flu Map for the specific parcel 5-1 South 31 1101 00000, requesting that the change the existing flu designation from public to mixed-use urban for 269.29 acres and commercial of 269.81 acres. All right, John?
All right. Thank you, Chair and Board. We do have DBZ on Teams with us as well. DBZ, can you hear us?
Yes, we can.
Okay. DBZ, I'm going to go through staff findings and kind of a synopsis of what's going on. And DBZ would just want to give their recommendation is what they're going to do about, this one. If the board remembers, in June, we had a large-scale LS 2021-01 for the same property. The difference in the two, the first one that you did, there was a total of 81.28 acres of commercial that you have recommended to the Board of County Commissioners. At the time we took it for the consent, the board, some members of the board had asked to bring it back with a larger amount in the northern, making the northern half commercial, all commercial until the year 2032. The reason for that, because 2032 is when the master plan now allows for residential. So if we didn't change back in 2032, it would be non-compliant with the overall master plan. Okay. We had brought the question to DEO. DEO does not, the statutes, state statutes do not allow for an automatic revert back to a mixed-use urban come 2032. So therefore, it would be, this is a quick synopsis, therefore, if this was a recommendation from the board and approved by the BCC, whoever the property owners are on the northern half of this proposed future land use would have to make a request, or we'll put it in a, try to put it somewhere in the land development code that this would have to change back to mixed-use urban come 2032 in order to meet the compatibility of the design code for the master plan of OF8. So I'm going to go through the findings. We'll go through some maps here. I'm just trying to give a little synopsis on how we go, and hopefully things clear up a little bit. So this is, this was brought down from the BCC as a recommendation from you, the board. So at the very end, it really comes down to, do we recommend this one or do we recommend the previous one? Okay. All right. Yeah, we'll go through the maps. So as we remember, this is the location of OF8. This is the wetlands. This is the current zoning public. This is existing future land use public. And this is the new proposed for LS 2021-02 of the future land use, making the northern half of 262 acres of commercial there. Okay. This is the aerial map. This is the public hearing sign. This is looking west along 9 Mile. It's looking south across 9 Mile. This is looking east along 9 Mile. This is looking from 9 Mile at OF8. These are the two public hearing signs. You can see, the first one that we had, and also the new one, 02. And this is on Frank Reeder Road, public hearing signs. We put it on the north and south side. This is looking north across Frank Reeder Road. It's looking south across Frank Reeder Road at OF8. Okay. And I'll go through the staff's analysis here, just for we can understand the two differences between. Okay. So this is a map amendment change from future land use category of 539.1 acre plus or minus acres of the future land use public to mixed use urban on 269.29 acres and commercial on 269.81 acres. The zoning for the majority of the reference is public with 61.02 plus or minus acres, having no zoning destination as well. The applicant is aware the current zoning and proposed future land use are not compatible as we are waiting for the adoption of the new master plan called OF8 Master Plan District. This will be part of Chapter 7 in our Land Development Code. I'm not going to go into all the details of the location there. We were kind of aware of that. The analysis of facilities and services, the availability for public services inside the future land use map amendment requires analysis of the general demand of its proposed all Pacific levels of services to be established. Escambia County is evaluated in compliance during the review process prescribed by the LDC for approval of the proposed development. The applicant must coordinate with the local providers to ensure that is available. Once the project is submitted, all the LOS will have achieved and be further evaluated during the site plan process. The subject property is within the service area of Escambia County, Emerald Coast Utility Authority for sanitary sewer connections to the ECA system in compliance with the requirements and responsibility of the developer. The solid waste, the Perdido Key landfill build-out of 424-acre landfill facility is 74 acres. Based on the population growth projections, estimate the annual class of 1 million solid wild waste received. The estimated remaining life of the landfill is 68 years. Once the project is submitted, the level of service will be evaluated through the site plan process. Portable wells. At this time, there is no portable wells on this site. Or around this area, but that can always change as wells are needed in the area with the growing infrastructure. Stormwater. The applicant has a document and understands the requirements for the stormwater management. The applicant acknowledges the separate requirement and permitting through the state agencies such as Northwest Florida Water Management District may be required. The OF8 master plan will have its own stormwater requirements. They will be somewhat compatible to the state design manual with the LDC. As of right now, there are no restrictions. We are still trying to implement a new code for that area for the outlying Field 8 master plan district. The streets and accesses, TTO staff did review the staff analysis for the build for this area. There is a master transportation designed that is part of the OF8 master plan. With the daily traffic volume, 9 Mile Road was recorded right now at 14,500 for year 2019-2020. The daily traffic was 1,523 for September 2018. These are just the current traffic models right now. The overall master plan has taken account for the overall growth of OF8 and the design of it for future. Public schools facilities, this is suitable for map amendments for the proposed use requires analysis of characteristics of the site and its resources relative to the comprehensive plan. These will also be evaluated during the site review plan process. All right, the impacts on land use. The current public is intended to provide uses or facilities owned by the managed for the Florida State or county government and any public institutions or agencies. A range of allowable uses from parks, local, regional, state, and federal facilities, public structures, land uses, and providing public services. The mixed-use urban future land use of 269.29 acres is intended for a mixed-use residential and non-residential while promoting compatible infill development and the separation of urban suburban land uses. Range of allowable uses in residential, retail, professional offices, light industrial, recreational facilities, public and civic, and light agricultural. These are all the same type of uses that are allowed in commercial as well. The commercial future land use allows all the same uses as a mixed-use urban, but the difference is the commercial future land use only allows residential as a secondary component, not as a primary component, okay? So that's one of the key things there. So Escambia County is we've already gone through this. Escambia County is proposing a text amendment, CPA 2021, that we did in June to allow for a increase in density and floor area ratio for certain areas of the OLA master plan. The OLA master plan on the northern half where the commercial future land use is proposed to have the western side of 188.53 acres amended to mixed-use urban in 2032. As part of the OF8 regulating master plan, area 1, 73.47 acres will be the only commercial future land use area on the northern half. See Exhibit C. I can go to those exhibits in a second. This would change to allow residential to the primary use 2032 maps 3 and 4 of the OF8 design code. See Exhibit D. Commercial future land use only allows residential as a secondary use and would not be compatible with OF8 master plan in 2032. Escambia County and or other property owners would have to amend the commercial future land use in 2032 to be compatible with the OF8 master plan. The impact of wellheads, again, there's no wellheads currently located on the property. During the site plan review process, we would locate if there's any new wellheads in the area and adhere to any changes that would be needed. Impact on natural environment. At this time, Wetland Sciences did a full assessment of the original 629 acres. That has all been part of the original master plan design to incorporate any of those valuations that were done at that time. The future land use map designation, the proposed amendment is within the proximity extension and infrastructure that is utilized by the other similar uses in the area. The development promotes the principle of a good development by taking advantage of Interstate 10 and existing roadways. As a result of the proximity of the similar existing, the proposed amendment would reduce transportation costs, including per capita costs to consumers to own, operate vehicles, road, parking, cost facilities, traffic accidents, and pollution emissions. The proposed amendment will ensure that the proposed development is conducted in an efficient manner. Specifically, the proximity of the subject property to other existing development will provide an efficient integration of infrastructure and services that will conserve both water and energy. All these are part of the same large scales, 01 and 02, all have the same compliances with all such factors there. Existing facilities, the existing facilities all be part of the overall design. The future land use map amendment would be consistent with Navy Federal's credit union property to the east that already has a mixed-use urban, talking about the southern portion of that. If we can go to, I'm going to pull down. So these are the exhibits here. This is Exhibit C. So this is what would have to be changed. This is what was approved as LOS 01 that the board recommended in June. This is what it would have to revert back to come 2032 due to make it compatible with the overall master plan. And the reason we say 2032, if we look at here, this is part of the overall design code. You can see we have regulating plans that every 5 years we have a change in certain parts. This is part of the hybrid plan to help control, to allow most of the commerce be developed that can be developed, and every 5 years we kind of take some of that commerce area away. Okay. And there's also the regulating plan, which I show here, Area 1, Area 2, Area 3, Area 4. So what we're saying is Area 1 must be at least 80% built out until we can move into Area 2. Okay. All this part in white here is not part of the regulating plan. This can be built out at any time. Okay. Just trying to make sure everyone understands. So 80%, or if there's more acreage that is needed, that is left than what is, if they need 130 acres, then yes, Area 2 could be opened up because there's only, say, 40 acres in Area 1. So that is, again, part of what we see here above. Development Area 1 through 4 shall be developed in sequence and shall require development permits on 80% of the development area before the next development area is to be open for development. These are showing the, kind of the, zoom out there. So these are the zoning maps, 2021, 27. Zoning map 22 is 27 to 32. And then once it hits 32, this is why this northern half is where we start allowing residential. We don't allow it until 2032 from the design code at this standpoint. So you can see the changes here. The southern half being mixed-use urban would have no effects. And this would be Exhibit D, showing the changes come 2032 to 2037. So there is language that will be put into the design code. This language is in design code, which kind of regulates this already from the commercial aspect. The question is the commercial having this extra layer of commercial future land use on the northern half of the entire site needed for this? So this is the question to the board. Do we want to add to keep residential out? Again, no one can build on the northern half until these areas are built out or you reach those dates. It's kind of confusing. I'd like to give you guys confusing ones.
So I got a
and
question.
I can let DBZ probably explain this a little bit more better entirely about the process of development. But yes.
So are these hard-coded dates? In other words, if 2027 comes and there's not enough commercial building, and it starts to go away from commercial and back into residential, are those hard dates, or they can go, hey, 2027 came or 2032 came, and we're not quite there, but we know that the need for commercial is still relevant?
So there is a part in the code that basically says if there is a application under permit or shall be reviewed under a prior regulating plan or a signed letter of intent. So if someone has something a year before the date is up, if there's a signed letter of intent or anything like that, that we can hold off that area moving forward, or they would be, the area they designated, that would still fall into what they're looking to do.
So in reality, the dates are pretty hard-coded in.
They're hard-coded in, yes, as of right now. There's been a recommendation from one of the commissioners to actually, and has not been approved yet, because we have not approved the master plan, to actually, this would come, anytime these dates, once we hit these dates, basically the month prior to that, the BCC will actually have a vote whether to proceed with the plan or if they want to hold off.
Okay, all right, that was going to be my, question is, we may not have, there may be, development's such a weird thing, and you say, okay, we want to now convert this to residential because residential's hot right now, so these dates, when we're looking at right now in 2021, look like great dates, but when you get down to the 2027, 2032, so far away, and all of a sudden you start taking away commercial opportunities because they're hard dates, that just makes me a little nervous. So I'm glad that the BCC is looking at putting some wiggle room in there that, you can hold it for 12 months prior if there's a letter of intent, but also BCC can make a decision to say, no, this isn't we're not moving this into this section yet because development commercial is going fast, but it's not going fast enough to develop it, but we want to, you understand what I mean?
And Mr. Reed, thank you, John, you're making a very, very valid point. Because that's the intent of the purpose of this plan. Yes, bringing residential, but you do want to get some commercial development. And you do want to have opportunity to preserve and to protect the commercial property so that it can, because of course, revenue, tax base, you want that quality control out there. You don't want, you want that neighborhood environment, but also to one of the primary, and it's stated, it has been stated over and over again, one of the primary intent of the option for this, you want to make sure that you have equitable, a return on investment, and that comes back through residential, but also through commercial as well, commercial revenue as well.
And if we look at kind of this map 3, map 4, the Z4 here in the northeast corner, that will always be, that's in perpetuity, so that never goes away. And even Z3, the strips along the side here and up here, so there's still quite a few, commercials all the way up to 2037. That will be, you're looking at 100 plus acres there just set aside.
And also, too, and I would like to add in, please, and if I'm saying anything incorrectly, that's why we have the planners, the firm, to help make sure that what I'm saying is absolutely correct. It's my understanding from my meeting and from my discussion with this, is basically this option that is before you today, basically is to help, is primarily recommended to help provide more of an illustrative intent, of the expectation of the development of this parcel of land. Yes, the controls are already in place. Basically, if the board approves and go forward with the proposed implementing plan, but this is primarily to provide a much more visual intent so that the public would know that this is primarily, we want this to be primarily for commercial. Yes, so we already got that in place, but to provide visual sometimes can help guide things, and that's the purpose of it. And this is the expectation that this BCC will be hearing on Thursday. This illustrative intent to promote the primary intent that they want this portion basically for commercial. So that's the expectation, and it will be going to the board on July the 8th.
Do we have anything from the consultants that they want to add?
DBZ, do you want to comment at this time?
No, not at this point, unless you have specific questions.
Any specific questions? All right, we do have a speaker signed up on this one, Mr. Larry Downs.
Larry Downs Jr., 12156 Habburg Drive. Pensacola, Florida. Lots of big governance here. All over all this stuff. The applicant is our own government. I just want everybody who may be watching this to understand that. It's our own government, isn't that right?
Yes, the county
Yeah.
owns this property, yes.
So I don't know why they say the applicant this, applicant that. It should be, hey, our government wants to do this, which is more big, I don't even think we should have been in this position to begin with, but we're here. Also, I think anytime the applicant is the government, those public notification signs should be a lot larger, because there's nobody here. Maybe make them 4 by 8 on all of those major roads around there, and you might get a few more people who may do some more research, because I haven't been following this OLL, whatever it is. But I do know it's government, and it's government investment of our money, of our property and all that. And I know this isn't, it isn't directly related, but it is. It is. Y'all are making decisions with our money, with our future money, with our future investments. So make sure y'all completely understand this type of stuff, because, it comes through, rolls over, and we're just going to hope for the best. All right. Thank you. I'm not for or against this because I haven't researched it, but I just think the applicant should be, we should say government instead of applicant. Thank you.
And I do want to respond to Mr. And I know I should not do that, so I may be biting off one of my shoes right now. Tread lightly, absolutely. But I do want to step up the record, Mr. Downs. You may not have been involved, so I don't need a response. You may not have been involved, but believe me, this project has been is well known for the community in that area. There have been many charrettes, many comments, many meetings, many statements, possible even newspaper articles on this. Is you just may have been extremely busy with your job that you do very well. So I just want to state that the county, the public, the community is aware of this project.
And one more comment to Larry, because as a rights activist that you are, the idea is that the government is developing this to sell to the rights of people, so that people then will actually own and control. So that's actually a good thing. That should be something that you're excited about, that the government is letting go of the property for the people to have it. So I think that would be a good thing for you.
I get that, but the government makes big problems and big decisions like that, and they make mistakes. Remember the soccer complex that was going to come up? I think we even had a county commissioner go to prison over it. I'm just saying, the more we do, that's all I'm saying. I know there's been a lot of talk about all of this, but in 10 years, let's see what happens.
I'll be retired.
Everybody try to get out of here by then.
Horace, you may or may not know the answer to this, but being that this is 11 years away, or at least 6 years away when the first trigger hits, how does the county or your staff or the commission track that these are coming up so that the dates are, like you said, they're going to be submitted before the dates happen? How does that happen internally?
Because of this implementing plan, and if everything hopefully goes well and is adopted, we'll make sure we have with our good GIS and technology, and we'll be able to track these development orders. We'll be able to tag them. Tracking is because of the different technologies that we do have developed in our processes. We definitely will be able to make sure with the development orders that we issue with the processes that everything is in alignment with what is approved on the implementing plan and this process going forward. But it will be a master plan. So
Yeah.
all that will be
I just would want to make sure that
Yes,
if someone, a private citizen or a private company purchased a piece of property in there and that they were fully aware of that there's some changes that happen and the certain triggers that would come. I would imagine that the county would disclose that in the sale documents and everything like that.
Yes, sir, we'll make sure, if the county, yes, on you, we'll make sure all of those things is properly disclosed on all public record we'll have a website and all of those things, yes, sir,
Okay.
definitely.
I guess that's where I'm a little confused on triggers of development and the identification of development when a date comes. I wasn't here in June. I haven't looked at this in a long time. I can't remember if it was decided what percentage the county was going to plan to sell out of the master plan or retain ownership and lease. But let's say we sell a piece of property to a commercial developer who has a 10-year plan, but the development does not take place by a trigger date, but the ownership is still under that developer. Where does that leave him in a trigger date?
Well, we just don't, I mean, there's gonna have to be some earnest intent. They're gonna have to be, I mean, there'll have
Yeah,
to be
he
some
may
skin
have
in
an
the game.
LOI, but he may not have a master plan of his little property developed yet. But it could be a big developer that you know they're gonna make good, but it may be a 10-year plan.
As John stated, again, those things, I mean, we just don't want no wishful thinking, and the board will be monitoring that closely with the team, with the Board of County Commissioners. There gotta be some earnest intent on that, some submitted and documentation going
So
forward.
they need to know going in on the
Yes, sir.
purchase, this is not a spec purchase.
Absolutely.
You've got to.
Yeah, there's some, the overall master plan is a lot, very detailed once we actually open up the design code documents.
Yes.
As you see on here, we have Z1 through Z6 and civic zone areas. Those get a lot more detailed in how you design, how you build. When you do your development order, it'll be right up front. There's a whole nother code for this, and this is how it gets built out. You gotta follow these regulations, so.
So with these trigger dates will be contingencies upon the purchase.
It can be. If someone wants to buy something in the northwest corner to try to do something, they gotta wait for a certain date or wait till everyone else is built out, So they have to be aware of such little things or go to the code would have to be changed. The design code itself would have to be changed if something, didn't grasp at a certain date. But, they're buying, it's to be built from the south end up, except for that northeast corner where it's essentially the start of the commerce area. So, that's the intent of the code, not just sporadic part here, part there.
Right.
Uniformity, that's what they want. More uniformity, they want proper planning, they want smart growth, they want smart development, they want urbanized. So predictable planning, and that's the purpose of having a master plan. So hopefully, and it can work, we just gotta, and we're gonna make sure that everyone is aware of the steps and the criteria and the triggers going forward, going in.
These sections are the language there is strict, straight out of the code, design code. So, that, you wouldn't expect someone to buy anything, or at least they'll go through a pre-application. This will be given to them at that time before they get a development order. These are the things you have to do. It's the same thing as the sector plan. We have people come in, like, you have to show us every little detail, cross-section, how you're building it now. It's not a regular putting up a McDonald's anymore. It's, you have these details in order to meet before you get your development order. We have to see these extra sheets of what your crossroad look like. You just can't just put any regular road in. We have to see every detail before we move forward.
Okay, Jay?
Just out of curiosity, on Area 3, why is that little extension on the southern boundary?
That's part of the zoning category. So I go back to, see the Z5, it drops down. So we're just following this line. So we're following the zoning lines and coming down.
No, I understand. It stands out more on, if you look at the proposed flu
Yeah.
map. I was just curious as to why it,
Let me see.
if you keep going.
Mhm.
Yeah, there you go. Just a little.
We follow the northern part of the road, and we do want to make sure we capture that zoning, the Z5 area, that we got its entirety in there. You know, the roads won't have zoning once they're actually developed, and these roads, there's so many of the roads that actually are part of the regulatory plan, the ones that go north and south and a couple east and west, that cannot be moved. These are part of the plan. We'll have a center line GIS file, so they can't come in and say, I want to put the road over here instead. No, the road is part of the plan. And this is a very detailed plan.
Yes, it is.
We have nothing like this in the county.
So that's where the road kind of extends down to the south a little bit.
The road would, basically, you're looking at, you know, this is the northern right-of-way line of the road that you saw. So,
And we'll be coming back if the board tell us to proceed with one of these options, and then we'll be coming back with the implementing plan. We'll be getting into the details of all of these things about the zoning and the roads and the performance standards. All of those things got to come back to this board and DPZ, and they're working with us and doing a good job with John and Terry and the whole county, and trying to get these implementing the language for the proposed draft to the board, so we can start looking at it and y'all can have more engagement.
No, I wasn't trying to be nitpicky, it just kind of stood out, and I just had a
Sure,
question
yes.
for my education. Thanks.
Is this basically a question for Mr. Fisher and Marina, possibly? Is this, in essence, aligning our future land use with what the OLF master plan intends to do, so that they're in sync going down the road?
it lines them until 2032. Then come 2032, whoever's the property owner of those northern parts, except for the 73 acres, everything in this area would have to be converted back to mixed-use urban by, you know, the owner or the county, whoever's the owner at that time, in order to build towards the code, because they will be incompatible. So that's the issue. But what it's doing is adding an extra layer of making sure some builder doesn't just come in and buy and try to change everything in 10 years. But we already have some of those regulations in there by what we put in the land development code. So this has got to be in the land development code saying when they can change, you got to meet the 80% rule. So the regulation's already there. We just have one of the BCC member, you know, wanting to find another regulating thing. It's just the question is, you know, if we go down to the very bottom here, here are the differences. You know, we thought we could have it automatically revert back. That was the whole question at the BCC. We contacted DEO. DEO said we cannot have it automatically revert back. So it's got to be up to the property owner come that time to make their property compatible.
Okay. All right, board members, any other questions? Anything else from DPZ?
No, I think John explained it well. It's we're trying to provide as much flexibility as possible to make the commissioners happy, yet give this parcel the greatest chance of success by virtue of this sort of split zoning that comes into effect 15 years from now, or 10 years from now.
All right, thank you, Marina. All right, board members, if there's no other questions, Chair will entertain a motion on moving this one forward.
Please be clear which one we would like to, you know, are we moving forward with this one? And we recommend to, you know, not go with the 01 now. Yeah. So we need to be clear for they understand which one the board recommend. We can't have both of these move forward. So we're basically kind of erasing the 01 if you want to move forward with 02, or we don't want the 02, we want to move forward with 01.
Okay.
Based on findings of staff and the application, I make a motion that we move forward with 2021-02.
Okay, recommendation for 02. Do we have a second?
I second that.
Second, any further discussion? All those in favor of moving 02 forward, say aye. Aye. Opposed? All right, did everyone vote? Motion carries unanimously then. So recommendation is to move forward with the 02 plan.
Mr. Chairman, and could the board clarify that that is to replace their previous recommendation to move forward with 01?
Okay. amend your motion?
I amend my motion to state that 2021-02 will replace the proposed 2021-01.
Okay, does the second still stand?
Second stands.
Okay, let's vote again. All those in favor with the amended motion, say aye.
Aye.
Opposed? Motion carries. All right.
Thank
there
you.
go. Sure thing. Okay, action discussion items. Do we have anything on the agenda today? Nothing noted. Public forum. Anyone wish to speak in public forum? All right, no speakers. Horace has stepped out. Anyone from staff have anything? Drew, John, anything for director's review?
No, I think we're kind of looking kind of clear right now. Pretty good moving forward.
Okay. Kia, anything from county attorneys?
Nothing from me, thank you.
Okay, and then we have, go back just to our monthly action follow-up report for 6-month outlook. We have any idea what it's looking like next month and what we have coming?
You know, maybe a rezoning next month. Maybe also possibly maybe bringing a draft of 8 or the next month after that, just to get you guys familiar with it, because we'll have to eventually bring that for a recommendation to follow up with the transmittal.
So that would come as maybe a discussion item?
Yeah, discussion item. We can't move it forward to the BCC. I mean, we can always move forward. That's something we're got to figure out. What would the board, let me ask, recommend? Has that kind of discussion item just go through? I mean, we had one previously. The next part's basically just got to bring what we're going to be inserting into the LDC. We're going to call it Chapter 7 now. It will be the OFA Master Plan District, and Chapter 7 is what it will be called. So basically bring that forward to you. It's got to show all the design elements, the stormwater elements, transportation elements, and that just needs to be moved forward to the BCC. But and that would be sometime in probably September, October when the BCC sees it, because we have to, it's one of the like future land use has to come first, the transmittal has to come back from DEO. They approve that, then this will follow right on the same, hopefully the same night. They say, all right, now we can approve the master plan and move forward.
Okay, so as far as if it comes to us as an action item, discussion item, is there any different notifications for the public? Because I know this one has high public interest. Would it still be required to be advertised as coming to the planning board?
It will be advertised, I believe so, as an action item.
Okay. Okay. Board members, anything else? All right, our next regularly scheduled meeting will be for August 3rd, which is Tuesday at 8:30 here in this room. If there's nothing else. Oh, Rachel?
Can we make them vote on the minutes?
Oh, did we not? I'm sorry.
No.
All right, the previous meeting minutes from the June meeting has been presented. Is there any additions, deletions, or corrections? Hearing none, Chair will entertain a motion to accept as is.
Move to accept.
All right. Motion, do we have a second?
Second.
Second. All those in favor say aye. Aye. Opposed? All right, thank you. Thanks for keeping me on my toes. I missed that one. We're in a hurry to get into the public hearings. So if there's nothing else, then we are adjourned. Thank you for coming.